Hey, welcome everyone to the Talking Animals Law and Philosophy series. You're joining us for the last event actually in this academic year. There'll be more events next year, but this one wraps up this academic year. My name is Raphael Fazel. I'm the Executive Director of the Cambridge Centre for Animal Rights Law. Some of you may be joining us for the first time in the Talking Animals series, so just going to say a few words about the format of the series. We will start with a presentation by our speaker that will last somewhere between 30 to 45 minutes, and we'll then have quite a lot of time for discussion, around 40 minutes or so. I normally encourage people to participate in the discussion because it's a nice way of sort of talking to the speaker and engaging with their ideas. If you'd like to come in with a question or a comment, please use the raise hand function that you can find on the bottom of your Zoom app. If you're traveling or in the library somewhere, you can also just use the chat function if that's easier. You can just type your question or comment into the chat and I can then feed that to our speaker. That works too. I will mute all the microphones until we get to the discussion part. We are recording this event and we'll put the recording of the presentation on our website later today, probably, or tomorrow. We will, however, not record the discussion part, so you don't have to, feel inhibited. You can just come in with a question or comment. It won't be recorded. Very good. I think that covers it as far as the format is concerned. And it is now my pleasure to introduce our excellent speaker, and that's Matthew Liebman. Matthew Liebman is Associate Professor and Chair of the Justice for Animals program at the University of San Francisco School of Law. Matthew graduated with a distinction from Stanford Law School and with highest honors from the University of Texas. He clerked for Warren Ferguson of the United States Court of Appeals for the Ninth Circuit. And before joining USF, he practiced law for 12 years with the Animal Legal Defense Fund, where he was also for 3 years the organization's Director of Litigation. Matthew's published a lot, and his research has appeared in many different journals, including the Ecology Law Quarterly, the Animal Law Review, the Journal of Animal Law, and the Stanford Environmental Law Journal. And he's also co-authored an excellent book called A Worldview of Animal Law. His current scholarly focus is on the ethical challenges of representing animal clients, which is a fascinating topic. Today, in fact, in his presentation, he's going to be considering some aspects of this current research of his. His presentation is entitled Animal Plaintiffs, and it is based on a forthcoming article in the Minnesota Law Review. Matthew, thanks so much for being with us. The floor is yours.
Thank you so much, Raphael. It's really an honor to be here. I've attended a number of these talks in the series over the last couple of years, and I'm always really impressed by the intelligence and the passion and the commitment of the presenters and of the audience, for that matter. So I hope I can live up to the standard. But it's really a pleasure to be on this side of the conversation. Let me share my screen. All right. So as Raphael said, I'm going to be talking about an article that I've written that's been accepted for publication by the Minnesota Law Review, which I'm excited about. It's a general interest law review, highly regarded, which I hope will help bring some of these ideas that I know a lot of us are quite familiar with into a new forum and reach a new audience of legal scholars. It's slated for publication in April of 2024. So plenty of time for revision. So I'm excited to get your feedback, your impressions, so I can continue to refine the concepts and hopefully put the best case forward. So the purpose of this article is to defend the plaintiffhood of non-human animals. That is, to propose a framework for recognizing sentient animals as legal subjects who can civilly defend their substantive rights. And this article arises out of my own representation of an animal plaintiff, as you can see from the image here, a horse named Justice. So some of you may be familiar with the case of Justice versus Virtue. If you're not, it's a case I was a lead attorney on. Justice was a horse who was left out in the cold Oregon winter, suffered from severe neglect, including frostbite on his genitals. When he was rescued, he was several hundred pounds underweight and had a number of painful medical conditions. Fortunately, he was nursed back to health, but as in a human case where someone has been injured by the negligence or neglect of another, we decided to file a lawsuit with Justice as the plaintiff, seeking damages under a tort theory of negligence per se. And so this article, I think, deals with a lot of the research and thinking that I had to do in litigating that case, and some of my own frustrations with how the judges in the case were thinking about the issues. And I wanted to create a more kind of scholarly framework for thinking about the phenomenon of animal plaintiffhood, and to make a case that would hopefully ultimately lead to the ability of animals to defend their substantive legal entitlements. So here's a bit of an overview of the talk today and an overview of the article. I'm going to start off with sort of a descriptive section talking about cases in which animals have already been named as plaintiffs in court, then move on to the normative case for why we might want to recognize animals as plaintiffs. Third will be the conceptual, philosophical unpacking of what the concept of plaintiffhood entails and whether or not animals can meet those conceptual and philosophical expectations. And then finally, engagement with the juridical and jurisprudential questions of animal plaintiffhood and the categories that are not only conceptually contained within the concept of the plaintiff, but the legal requirements of what we expect of plaintiffs. So let's start with that first, the descriptive animal plaintiffs in court. So in my research, I've found, and I have to acknowledge that my focus here is the United States, perhaps parochially. My training and background is in US litigation, so that's the focus of the article. Of course, there's been lots of really important cases filed internationally with animals as plaintiffs, but for purposes of this paper and this presentation, I'm going to be focusing on the United States. So in my research, I've found about 30 cases filed in US courts, both state and federal, in which animals have been named as plaintiffs. Some of these are on behalf of individual animal plaintiffs like Naruto here, like Justice the horse. Others have been filed on behalf of species like the Palila in the middle here. But there have been, as I said, a couple dozen of cases where either individuals or species have been named as plaintiffs in litigation. The first case that I've been able to find is a 1972 case out of Brazil, one example of an international case I do talk about that sought a writ of habeas corpus on behalf of all birds in captivity. It was filed by the Brazilian SPCA along with an author named Fortunato Benchamal. You can see his book here on the left. But the case was ultimately dismissed because the court held that animals lacked legal subjectivity, they could not be subjects of rights, and were mere objects. Now, I do want to sort of note that case as the first one internationally that I was able to find, but the first US case was filed just a year later in 1973 by Hank Holzer, who was sort of the first animal rights lawyer in the United States, in which he named an animal rights activist named Helen Jones, as you can see in the caption here, as next friend and guardian for all livestock animals awaiting slaughter in the United States. And this is a challenge to a federal law called the Humane Methods of Livestock Slaughter Act, but the court did not address the propriety of naming the animals in the caption as being represented by a next friend or guardian because there were human plaintiffs in the case, so the court was able to dodge the issue. But just sort of to add that element of history, it's been sort of 50 years of animals being named as plaintiffs. And from these early efforts, other lawyers have sporadically named animals as plaintiffs in a variety of cases over the last 5 decades, raising a number of different claims. Some of those claims have been statutory, so attorneys have named animals as plaintiffs invoking claims under the Endangered Species Act, the Administrative Procedure Act, the Marine Mammal Protection Act, the National Environmental Policy Act, Americans with Disabilities Act, and the Copyright Act. There have also been constitutional claims brought on behalf of animal plaintiffs, including a claim under the 13th Amendment to the US Constitution, which prohibits slavery, and then a claim under the Bill of Attainder Clause, which prohibits legislatures from creating punishments through legislation targeting a particular group. And then the Another class of claims have been common law claims in state courts, including the habeas corpus litigation brought by the Non-Human Rights Project, which I'm sure most of you are quite familiar with, and negligence claims like the one brought on behalf of justice. In virtually all of these cases, judges have been quite resistant to the idea of animals as plaintiffs, although not uniformly so. And we'll talk a bit more later about the grounds on which courts have expressed their skepticism about the capacity of animals to be plaintiffs. Okay, so that's the descriptive piece. That brings us to the normative question of why we might want to recognize animals as plaintiffs. So what ends are served by animal plaintiffhood? And I think there's at least two reasons that I go into in the article. And the first is a justice-based argument. If we believe that animals have a normative entitlement to substantive justice, then they ought to have procedural access to the forums we use to defend and protect those substantive entitlements. And I do think that animals have a normative entitlement to substantive justice. I'm sympathetic to Martha Nussbaum's capabilities approach. She writes, when I say that the treatment of animals is unjust, I mean to say not only that it is wrong of us to treat them in that way, but also that they have a right, a moral entitlement not to be treated in that way. It is unfair to them. And so if animals do have a normative entitlement to substantive justice, cashing that out in the terms of the law and the procedural mechanisms of enforcing those substantive entitlements is an issue of procedural justice. Also agree with Robert Garner that our moral obligations to animals entail obligations not only of morality, but also of justice. Garner writes, if we think that animals have moral standing, that we have direct duties to them, a relatively uncontroversial claim, then it is appropriate to frame these obligations in the language of justice, because justice entails legal compulsion. That is the ability to enforce one's rights through appeals to the apparatus of the state. Okay, so the second reason that I get into in the paper is a bit more instrumental. Setting justice aside, we've already determined, for example, that animal cruelty should be prohibited as a matter of policy. And if that is a public policy goal, that goal can be better accomplished by expanding the class of who can enforce those existing protections, be that the anti-cruelty law, be that federal regulatory law, and so on. If we just sort of are agnostic on the morality of it, we've established a public policy that leads in the direction of protecting animals from harm, and we can better enforce those laws if we recognize animals themselves as victims of violated statutes, be that the ESA, the animal cruelty laws, the Animal Welfare Act. We can better reach the policy goals that we've set through the democratic process. And this would help close what many critics have recognized as a major enforcement gap that we see in anti-cruelty prosecution, especially against politically powerful abusers, where we have laws that on the face of them prohibit the infliction of unjustifiable and unnecessary suffering, but in practice, because of the politics and economics of large-scale animal exploitation, those laws often go under-enforced. And so just as a matter of more effectively enforcing the laws we already have, recognizing animal plaintiffhood would expand the class of who can enforce those laws. Okay, so if we accept the normative justification for animals' entitlement to justice, then we have to consider whether it makes conceptual sense to talk about animals as plaintiffs. What is plaintiffhood, and can animals meet those conceptual expectations? Okay, so what is a plaintiff? Well, in the most basic sense, of course, the plaintiff is the entity that initiates civil litigation against a defendant. Simple enough, but that doesn't really tell us what kinds of entities can fill that role. So how do we answer the question of whether the class of plaintiffs could conceptually be thought of to include non-human animals, like, for example, Justice the horse? And so here in the article, I turn to the etymology of the term plaintiff to give content to the concept of the plaintiff. And according to the Oxford English Dictionary, the word plaintiff derives from the Anglo-Norman and Middle French words plaintif, which are the noun form of the adjective plaintive. So there's a connection between plaintiveness and the plaintiff. Plaintive means having the character of a lament, expressive of sorrow, mournful, and sad. The OED further derives the adjective plaintive, which again is sort of the adjectival form of the noun plaintiff, from an etymology that refers to lamentation, to being wretched or miserable, afflicted by sorrow, grieving, lamenting, even suffering. So we're starting to sketch this concept of the plaintiff as one who is plaintive, that is to say, one who is complaining about their suffering and their grief. And then to kind of further dig into the etymology, plaintiff and plaintive both derive from the Latin plaintus, which means a beating of the breast or lamentation, all of which I will argue is not unique to human beings, the beating of the breast in lamentation. So then conceptually speaking, we have a paradigmatic plaintiff as being one who is afflicted with grief or sorrow, who laments their condition by complaining. And again, the complaining word there is important as well, right? What does a plaintiff do? They file a complaint, which articulates their grievance and then calls on the court to remedy that grievance. And so to be a plaintiff is to be the kind of being who has interests, the frustration of which entitles them to complain about that injustice. Okay, so that leads us to the question, can animals meet these conceptual expectations of plaintiffhood? And I look at three different manifestations of, well, really the main question for me is animal sentience. So we'll start there, and then a couple of specific manifestations of sentience or animals' capacity to experience the world, one of which is called inequity aversion, and then animals' capacity for grief. So we'll go through those in turn. So starting with sentience, I don't think I need to spend a lot of time convincing this audience that animals are sentient. The scientific consensus is quite clear that there is something that it's like to be an animal, that many animals have a perspective on the world, and that perspective can have positive and negative valences. The positive valences can include things like pleasure, preference, satisfaction, joy, social connection, aesthetic experiences, arguably even spiritual experiences. The negative valences of animal sentience might include physical pain and all its multifarious manifestations, emotional suffering, loneliness, the frustration of instincts, anxiety, depression, to name just a few. And so to go back to Martha Nussbaum, it seems pretty evident that there is such a thing as the good for individual animals based on their phenomenological experience of the world, filtered as it is through the apparatus they have for experiencing it. Of course, how we define the good can get quite complicated and is going to vary from species to species, but certainly animals have some fundamental interests. There is a good for animals, there is a bad for animals. And the existence of animal sentience means that animals have interests. Their possession of interests gives them something to complain about when those interests are frustrated. They have something to be plaintive about when they are deprived from feeling the positive valences of experience. They have something to be plaintive about when they're forced to endure the negative valences of experience. I think sentience is enough, but there are more sophisticated and further manifestations of sentience that really demonstrate plaintive and complaining behavior. One example of this is what scientists call inequity aversion, which is a negative response to inequality among animals. We can bracket the question of whether or not experiments like this are ethical. I have doubts about the ethics of keeping animals in captivity and running these kinds of experiments on them, but there are experiments on animals that demonstrate that at least some animals resent inequality itself, even when they're getting an otherwise valuable good. So for example, the experiment depicted in this picture here involved training capuchin monkeys to trade otherwise valueless tokens in exchange for food rewards. And the monkeys were happy to exchange those tokens for cucumbers, which is a fine, they call it a low value reward, but better than a valueless token, right? But when the monkey's cage mate received a grape for exchanging the exact same token, the cucumber receiving monkeys got angry at the inequality, right? They wanted a grape in exchange for this token. And they ended up throwing the cucumber back at the researcher. They would shake the cages in frustration, all illustrating that even when they are benefiting above the baseline, the simple fact of the inequality was something that these animals had an aversion to. And similar results have been found in many species, indicating an aversion to unjust outcomes. That is, a capacity to complain about injustice. The final manifestation of sentience that I talk about is grief, which Barbara King has written beautifully about in her book, How Animals Grieve, with a lot of examples across the animal kingdom. Recall that grief and mourning and lamentation all figure heavily in the etymology of plaintiffhood. On the right is a picture of an orca named Taliqua, who gained international attention in 2018 after carrying her deceased calf, Tali, for 17 days across 1,000 miles of ocean, an evident act of plaintiveness and mourning. And when Taliqua got tired, other members of her pod would take turns carrying Tali's corpse, showing a sort of communal grief ritual. And researchers have found similar mourning behavior in other animals, including dogs and wild pigs and primates as well. Now, I want to be sure to emphasize, I don't think that either inequity aversion or the demonstration of grief in laboratory experiments or observed in the wild is a prerequisite for plaintiffhood. I think sentience, the ability to sort of complain about something bad being done to one, is enough to meet the category of plaintiffhood. But I do think these couple of other examples give a little bit more detail and nuance of how animals engage in plaintive mourning behavior. And so from these examples, I conclude that the existence of animal sentience, inequity aversion, and grief demonstrate animals' conceptual eligibility for plaintiffhood, and that the archetypal plaintiff includes the plaintive animal. Okay, but we're not done yet. Not every aggrieved individual, not everyone who's plaintive about something gets to be a plaintiff in a lawsuit. So having hopefully made the case for animals' conceptual plaintiffhood, we have to turn to the question of whether animals meet the juridical, jurisdictional, and jurisprudential requirements of plaintiffhood. So what is it that we expect of plaintiffs in civil litigation? Well, plaintiffs have to be legal persons. That is, they must be a legally recognized entity. They must enforce their legal rights through the litigation. They must have legal capacity, and they must have legal standing to bring the particular claim before a court. Now, I want to add the caveat here that I think there are persuasive critiques of each of these elements. I think the concept of legal personhood is potentially problematic for a lot of the reasons that Manisha Dekka writes about in her argument for refocusing on beingness rather than personhood, that maybe the idea of personhood might be fundamentally anthropocentric. I agree with a lot of the critiques of legal rights as being excessively individualistic. I think the concept of legal capacity is largely ableist and exclusionary. And I think the doctrine of legal standing is largely politics masquerading as an objective doctrine. It's really just a gatekeeping function rather than a coherent doctrine. All that said, these are the rules that are laid down, and I want to make a case for animal plaintiffhood within these limits, within these categories that the courts have said are requirements of litigants, while acknowledging that we may ultimately need to get beyond each of these categories. Okay, so these are the requirements: personhood, rights, legal capacity, and standing. And the question becomes whether animals can meet these jurisprudential expectations. So let's start with the question of personhood. So what is a legal person? I know this is a concept and a question that many of us have wrestled with quite a bit. To begin with, of course, we have to disambiguate the concept of the legal person from the human. There are already non-human persons under law, corporations, ships, municipalities, and there are non-person humans in the case of embryos or fetuses, historically in the case of enslaved people. And so we have to begin by acknowledging that personhood is not coterminous with the human. So if persons aren't humans, what are they? Well, the definition that I'm working with in this paper is that a legal person is any entity with legally protected rights to whom others owe a legal duty. Few sources of support for that position. Salmond on Jurisprudence says a person is any being whom the law regards as capable of rights or duties, whether a human being or not. Bryant Smith in Legal Personality writes to confer legal rights or to impose legal duties is to confer legal personality. So if society has conferred either rights or duties upon an entity, either through the common law, through the recognition of natural law rights, or through legislative enactments, then that entity is a person. And this essentially collapses the personhood question into the rights question. So as long as one is a rights-bearing entity under this interpretation, they would be a legal person. Now, of course, my working definition of person is not at all novel. Visa Kirky has described this as the orthodox view of legal personhood, and I'll mention his alternative view in just a moment. So how does this view relate to the view of other prominent scholars of legal personhood? Well, Ngiri Nafeen, who's a New Zealand legal scholar, describes personhood as a socio-legal construct that reflects normative cultural values about who matters. I agree with this. I think that's the reason that I argue that the social conferral of legal rights on a group through the democratic process, through positive law, or through common law, entails the recognition of at least a minimal form of personhood for anyone who has recognized legal rights. Stephen Wise argues that personhood is a legal conclusion based on one's normative entitlement to fundamental rights, which are in turn based on scientific evidence of one's abilities. I am supportive of the Non-Human Rights Project, but I do think this is an overly restrictive view of personhood. I think it may be correct as far as common law and natural law arguments go, but I think it undervalues the role of positive law, of enacted legislative protections in creating personhood through the establishment of legislative rights. And then I also agree with the concern that the focus on autonomy and liberty demonstrated through scientific evidence may be excessively anthropocentric, overly limited, and a bit too focused on animal similarities to us. Visa Kirky argues that personhood is, against the orthodox view, that it's a descriptive cluster concept that arises from one's possession of various active and passive incidents of legal personhood. So under Kirky's bundle theory, which seeks to accommodate the views of jurists about who is and is not a legal person, the possession of legal rights would not by itself be sufficient to be a person. Now, descriptively, I think there's a lot to recommend Kirky's bundle theory, especially from a descriptive perspective, but I'm not yet ready to give up on the orthodox view that personhood is essentially synonymous with rights holding. I think as Kirky himself notes, we could reconcile the orthodox view of legal personhood with jurists' extensional beliefs about who is and is not a person by either changing our theory of personhood, which is what Kirky proposes, or alternatively, by adjusting jurist beliefs to be consistent with the orthodox view in the case of instances where there are rights-bearing entities like animals. And that's what my article encourages, would be to take that second approach and insist that the orthodox view, that as long as one has rights, one is a legal person, is the way to go. That said, I have to admit that if the orthodox view remains incapable of achieving animal personhood, if judges continue to deny animal personhood under the orthodox view, it may ultimately need to be modified or replaced or abandoned. And the bundle theory might be a persuasive alternative for focusing on the particular incidents of plaintiffhood, particular instances of personhood, one of which might be the capacity to be a plaintiff. Okay, so alas, courts have disagreed that animals are or can be persons in the happy case, the New York Court of Appeals wrote, non-human animals are not and have never been considered persons with a right to liberty under New York law. In the Comerford Zoo case, the Appellate Court of Connecticut writes, a thorough review of our common law discloses no instance in which a non-human animal or a representative for that animal has been permitted to bring a lawsuit to vindicate the animal's own purported rights. And in the Justice case, the Oregon Court of Appeals wrote, a person with the right to sue to redress a violation of rights is and always has been a human being or an entity created by human law. So the article aims to refute the reasoning of these cases, which rely on historical arguments, linguistic arguments, and conceptual arguments against animal personhood, all of which I think are unfaithful to the view of personhood that I'm putting forth here, which is the orthodox view, the view that courts should be accepting definitionally. So let me offer just sort of a general summary of how courts are wrestling with this question. One is historical. Courts are holding that animals haven't historically been considered persons, which of course is true, but the past shouldn't dictate the present. If animals are now rights holders, they should be recognized as legal persons. Second argument that these courts are relying on is linguistic, that the term person is definitionally exclusive of non-human animals. But of course, language evolves, as does our understanding of the complexity of animal life and the evolution of our understanding of animals, animal minds, the expansion of their substantive legal rights, all should change the analysis linguistically. And then finally, conceptually, courts have held that animals cannot be plaintiffs or cannot be persons because they lack legal duties. But personhood doesn't require duties, only rights. And the sources that I've cited before are typically phrased this disjunctively, that a person is the subject of either rights or duties. And if we think of, for example, children or people with significant cognitive impairments, they are still recognized as persons with legal rights, even when they lack legal duties. Okay, so that takes us to the question of rights, right? If the orthodox view recognizes persons as those who have legal rights, the question becomes, what are legal rights and do animals have them? So we'll turn to that question now. All right, so the definition that I use in the article is something like this. Rights are legal relationships that protect the interests of their bearers for their own sake by creating duties upon others. And I am sympathetic to the interest theory of rights rather than the will theory of rights. The interest theory is the idea that the substance that rights protect is the interests of those who have interests rather than simply the autonomy or choices of those who have them. I think the interest theory resonates more with my own normative belief that suffering is a better moral baseline than cognition, but it also more accurately describes how the legal system talks about rights, including protecting the rights of those who may not have the capacity to make autonomous choices. From there, let me go to the question of, so we've talked about sort of what it is that rights protect, that is the interests of those who have them. I also want to acknowledge Wesley Hofeld. I don't think we can have a conversation about legal rights without at least mentioning Hofeld, who offered a schematization of legal rights in their various expressions and formal relationships in a pair of highly influential articles in the early 20th century. Now, Pierre Schlag said about Hofeld that reading him is like chewing on sawdust. I have to say this kind of Hofeldian analytic jurisprudence is not really my forte, but we do have to sort of acknowledge the sort of Hofeldian schematization of rights if we're going to talk about whether or not animals have them. So Hofeld described 4 general kinds of rights: claim rights, liberties, powers, and immunities. I'm not going to go into all of them. The only one that I want to focus on here, and the main focus in the paper, is on claim rights, which Leif Vinar describes as follows. So A has a claim that B phi, if and only if B has a duty to A to phi, where phi is some verb. So generally speaking, the idea is that if there is an obligation on the part of B to behave in a particular way towards A, then A has a right that B behave in that particular way. There's a correlative relationship between rights and duties, but not in the way that courts have said. It's not that for rights holders to have rights, they also have to hold duties. It simply means that for A to have rights, B must have some duties. So animals could have rights if humans have duties to animals. And I would add, if they have duties to animals for the sake of the animals themselves. And that's sort of focused on the concept of rights that I mentioned a moment ago. All right, so that takes us to this question: do animals have legal rights? And my focus here is on positive law, which does create duties for humans as regards animals. Certainly there could be rights outside of positive enactments. The Non-Human Rights Project has argued for the recognition of common law rights outside of the legislative process. There could also be sort of a natural law case for animal rights, but my focus is on whether existing positive law enactments on behalf of animals can properly be characterized as animal rights, and I think they can be. So if we think about things like the anti-cruelty laws, the Endangered Species Act, the Animal Welfare Act, other regulatory laws, the question becomes, are those protections for the sake of the animals themselves? Do they create duties upon humans to behave in a particular way towards the animals? And I think it is important to acknowledge that there may be laws concerning animals that don't create animal rights. The real question is, for whose benefit were these laws enacted, right? If we think about, for example, a law that prohibits livestock theft, that is a duty concerning animals. That is a duty not to steal animals, but it's not a duty to animals, and therefore doesn't confer any right upon the animal not to be stolen. It confers a right upon the animal's owner not to steal their animal, but it doesn't create an animal right. But in other cases where the laws are concerned with protecting animals for the sake of the animal, him or herself, that I think is a legal right. And in fact, those duties are owed to the animals themselves. A few examples here from courts analyzing anti-cruelty laws. In Stevens versus State, a Mississippi Supreme Court case from 1888, the court writes, "The Mississippi anti-cruelty statute is for the benefit of animals as creatures capable of feeling and suffering, and it was intended to protect them from cruelty without reference to their being property or to the damages which might thereby be occasioned to their owners." State versus Nix, an Oregon Supreme Court case from 2014, the principal purpose of adopting the legislation that became the Oregon Animal Cruelty Statute was to prevent the suffering of animals. And then finally, People versus Harris, a Colorado case, the language of the Colorado anti-cruelty statute demonstrates that the legislature perceived animal cruelty not as an offense against property, but as an offense against the individual animal. Modern animal cruelty laws reflect society's acceptance of the idea that animals have an inherent right to be free from unnecessary pain and suffering, and that the legal system should recognize that right. So here we even have the court talking in the language of animal rights. This accords with the view of many philosophers. Philosopher Joel Feinberg says, if we hold not only that we ought to treat animals humanely, but also that we should do so for the animal's own sake, something that can be claimed for them, something the withholding of which would be an injustice and a wrong and not merely a harm, then it follows that we do ascribe rights to animals. Cass Sunstein also writes, federal law has begun to recognize a wide range of animal rights in practice. It is entirely clear that animals have legal rights, at least of a certain kind. And finally, Saskia Stuckey, existing animal welfare laws could indeed be analyzed as comprising unwritten animal welfare rights as implicit correlatives of the explicit animal welfare duties imposed on others. So if we think about the obligations that these either anti-cruelty laws or other positive enactments, regulatory laws, the Animal Welfare Act, the Endangered Species Act, that they create duties upon humans in recognition of, if not the inherent value of animals, some intrinsic interest in not suffering. I do think we should recognize, as Stuckey does in her Towards a Legal Theory of Animal Rights, If we do recognize positive law as conferring rights, we should view these as simple welfare rights rather than fundamental rights, because existing protections leave animals' fundamental interests vulnerable. And where it does offer them welfare rights, those rights are highly infringible. That is, there's a low burden, a low justificatory burden for violating their rights. So I don't mean to suggest that the existing law is enough. I don't mean to suggest that it protects animals' fundamental interests, but I do think that they offer protections for animals. They create duties upon humans in a way that I think is fairly characterized as rights, and those rights could be enforced through litigation with animals as plaintiffs enforcing those rights. Alas, again, courts are reaching a different conclusion. In the Justice case, the Court of Appeals held that animals do not have legal rights. But in my view, the understanding of rights that the court is working with is unarticulated and frankly, rather confused. So the court writes, "Justice the horse is neither a human being nor a legal entity and therefore does not have legal rights or the capacity to sue to vindicate ostensible rights in an Oregon court. The statutory duty to provide minimum care to an animal in the custody and control of a person does not confer substantive or procedural legal rights on the animal. Rather, such duties qualify a person's right over a special form of property, one that is sentient and capable of experiencing pain, stress, fear, and suffering." I think this is a confused understanding of what a legal right is. If these laws create restrictions on humans' ability to exercise their rights over animals, they create duties for humans and they create duties for the sake of the animals themselves. And I think that is precisely what a weak animal welfare right is. And hopefully future courts addressing this question will analyze it somewhat differently. So in the interest of time, I'm going to breeze through the last couple of categories. These are capacity and standing. Capacity is the idea that the plaintiff must be free from a general disability and have the right to come into court. Generally speaking, the default rule is that every natural person of lawful age has the legal capacity to sue. So it's often treated as roughly synonymous with personhood, although there are some persons who lack legal capacity. The want here, reading here, this is a want of capacity to sue exists where there is some legal disability, such as infancy, lunacy, idiocy, coverture, want of authority, or want of title. And obviously there's a lot of ableist language in there and sexist language in the context of coverture or sexist concepts. And so, you know, the concept of capacity, I think, is quite problematic. But the important point here is that, at least in American courts, the lack of legal capacity is not a jurisdictional defect, and it doesn't mean the case can't be brought. It simply means that the case has to be brought by a representative to stand in for the person who lacks capacity, either a guardian or a next friend. So there are certainly infants, there are certainly people with mental disabilities who nevertheless, even though they lack legal capacity, can still be plaintiffs in litigation. So I do think that the way we think about capacity needs to be reformed, but I don't think the concept of capacity is a categorical barrier to animal plaintiffhood, precisely because we would need, we could overcome that through the application of existing statutes or the creation of new procedural mechanisms for appointing someone to stand in on behalf of the animal lacking capacity, either through guardianship proceedings or the appointment of a next friend. And then the last issue is the question of standing. Standing is the requirement that the plaintiff have a right to seek relief for the violation of the cause of action that they've claimed. This often gets conflated with questions of rights or personhood, but it's a narrower and somewhat more technical analysis that's very dependent on the nature of the claim and the facts at issue. Certainly one can be a person and still lack standing. It happens all the time. Many cases in US courts get dismissed for lack of standing, even though the plaintiff in the case is unquestionably a person with a capacity for legal rights. And so the question for me becomes, is there anything in the doctrine of standing that categorically excludes animals from the capacity to be a plaintiff with standing? Now, there are standing doctrines that exist in both federal and state courts. I'll talk quickly about the requirement in federal courts, but many state courts have adopted essentially the same test, although they might have exceptions and frame it slightly differently. So the federal standing requirement in US courts derives from the Constitution, which circumscribes the jurisdiction of federal courts, and it limits the jurisdiction of federal courts to the adjudication of cases and controversies. The Supreme Court has framed the test as requiring that the plaintiff have suffered a injury in fact, that being an invasion of a legally protected interest that's concrete and particularized, actual or imminent, rather than conjectural or hypothetical. There must be some causal connection between the injury that the plaintiff has suffered and some action by the defendant, and the injury has to be capable of remedy by the intervention of the court. Now, certainly animals can suffer injuries. Those injuries are caused by ascertainable defendants, and judicial intervention can alleviate those animal injuries. So I don't see any major hurdle here. Certainly animals suffer the same kinds of injuries that count for injury in fact in the human case. For example, physical injuries, psychological injuries, even financial injuries in the case of animals that have trusts, recreational injuries, procreational injuries, aesthetic injuries, and if all of these count in the context of human injuries, I don't think there's any principled reason for not counting them in the case of animals. And in fact, the Ninth Circuit has twice held that animals do have constitutional standing in federal court, that they suffer injuries, in fact, caused by defendants that are redressable by judicial intervention. The problem lies in whether or not animals have a statutory cause of action, whether they have statutory standing. And that's a much tougher hurdle to clear, but it's a case-specific and a statute-specific inquiry rather than a categorical impediment to animal plaintiffhood. So let me conclude by noting the presentation has defended the idea that animals are plaintiff subjects who suffer unjustly at the hands of human beings in ways that entitle them to plaintiffhood. Animals are subjects of justice, and their abuse ought to be included among the kinds of wrongs that our legal system recognizes as worthy of remedy. If we accept that animals have legitimate substantive claims to just treatment, fundamentally an entitlement to flourish, then animals also deserve the procedural access to the courts that guarantees those substantive entitlements. So I will leave it there. Thank you for coming. I'll put a link to the paper in the chat for anyone that wants to review it and offer any comments. I'd be incredibly grateful, but I'm really looking forward to your feedback, and I'm grateful for your being here today. Thanks.